Can you hear us? All right, we're ready to get started. As you know, this is one of our quarterly seminars for the maintenance clients, so it will be recorded on DVDs and sent to you. So if you don't want to take good notes, you'll get a video of this. If you want to get in the video, you can stand up and wave to the camera in the back of the room. We've got attending here as my partner Mike Gunning and I are going to give the seminar. We also have Matt in the back of the room, is another lawyer from our office. He's also a professional photographer. So he's taking some pictures for our website. So if you want to get in one of our website pictures, you can also turn around and smile at him. So Matt does all of our Medicaid planning and veterans benefits. So if you have questions on that, you might grab them at the end of the seminar. This looks like a pretty fun group. So we're going to talk about disability and death. So I hope we can have some fun doing that. I don't know how, but I see we have quite a few backup trustees in the group. I always ask the question, how many children are here? Children of trustees? How many of you have estate plans? A few of them do. If you don't have an estate plan, as a member of the maintenance group, we will do free powers of attorney and healthcare documents for any of your kids or parents. So you might want to keep that in mind. Also, if any of the trustees have young children, you should make sure you at least do a will, appoint a guardian. That's always kind of a drawback for people with young kids. Who will, if anything happens to you, who will take care of your children? That's pretty important. Okay, as I said, we're going to talk about the duties of a trustee. When does your backup trustee step in? There's 3 times that you might be removed as trustee. During your lifetime, we call it the changing of the guard. Who's going to be in charge of your trust? So we've set up all your trusts so you're in charge. But during your lifetime, there may be a reason why you have to step aside and let your backup trustee step in. When the first spouse passes away, if you're married, there's going to be a change. And of course, then when the second spouse passes away, there'll be a change. So the first thing we want to look at is during your lifetime, voluntary removal. Sometimes we have clients that come in and say, I've been diagnosed with Alzheimer's, Parkinson's, something like that, and they decide it's time to start preparing for when they won't be able to be trustee. What we usually do at that time is put one of their kids on with them to prepare for that, to make it easy when that time does come about. That doesn't happen very often, but it does happen sometimes. Sometimes we have clients come in and say, I'm just tired of doing this. I don't want to pay the bills anymore. I'm going to put one of my kids on in charge of trust. Sometimes a bank, not very often though, but once in a while we'll have somebody that comes in and says, I want my bank to manage my trust and pay the bills. They charge quite a bit, so that rarely happens, but once in a while. But it's usually kids that step in at that time. So that's fine then, because that's voluntary. So the client says, I want my child to be a co-trustee or trustee, and then we can just do the paperwork. What about involuntary? So that happens when it's not really your choice. When does that happen? That can happen through a court proceeding. So maybe you've become incapacitated. It's bad enough you don't quite realize you're incapacitated, and one of your kids step in to try to help you. You're still in charge of the trust. So it could be a situation where you have to go to court to make those decisions. Now, we've all heard horror stories where kids try to get control of their parents' estate when they're not really incapacitated. Those are battles sometimes you have to fight, whether you have a trust or not. But that doesn't happen very often either. We don't usually have to go to court to deal with these. What we've done for years and years, it's usually we use a doctor to prove incapacity. And all your trusts say that. So if your kids or your family don't think you're doing well, they can go to your doctor. The trust says if your doctor agrees you're incapacitated, that's proof. So then we can get the backup trustee involved. We're having a lot of problems with doctors, though, in the last few years because of HIPAA and also because of all the lawsuits out there. Doctors are a little afraid to get involved in people's estate plans anymore because they tend to get sued. So if they decide you're incapacitated, and because of that your backup trustee steps in and your backup trustee steals out of the trust, for example, the family may end up suing the doctor. So doctors are reluctant. Also, the new HIPAA law says it's a crime for your doctor to release your medical information. So they're reluctant to sign any letter that says you're incapacitated. So we have a lot of problems with doctors. So that's why in your trust we put in those disability panels. So all of you have a disability panel in your trust. Most of the time it's your children, sometimes it's friends. So the trust says if your panel agrees you're incapacitated, then that's the proof we need to put the backup trustee into the trust. So it's one of those, either the court, doctor, or panel. Panel's usually the one that's used. Doctors not so much anymore. So that's the first step. Now, if you're married and one of you become incapacitated, it is a good time to come in and see us and maybe update your documents. Let's say that my wife's incapacitated and she's my backup trustee and I die. She's supposed to be in charge of the trust, and now we have one of the kids as a backup to her. Now they've got to prove that my wife's incapacitated because the document says she's in charge. So if your backup trustee, whether it's one of your kids or a spouse, becomes incapacitated or passes away, you really should you should update your documents even though you have a second or third choice, because your second or third choice will have to prove that your first choice is not able to handle it, and HIPAA's made a lot of problems in proving that. So your spouse's doctor may not cooperate, or your kid's doctor may not cooperate. So anytime there's an incapacity or death in your chain of command, you should come in and let's just fix that. Also, if there's an incapacity in a family member and they're a beneficiary on your life insurance, on your annuity, on your IRAs, those should be updated also. If your spouse passed away and your spouse is a beneficiary on your IRA and you don't have a backup and you die, that puts your IRA into probate and all the taxes are due in 5 years. So anytime there's a disability or incapacity or death in your family, it's a good idea to at least call us and see how that's going to affect your estate plan, to see if it should be an update, just so there won't be a problem at that time. Now, lifetime removal. What happens in a lifetime removal? So let's say there is a removal of a trustee. It's either because the courts say it, because the doctor says you're incapacitated, or maybe it's because the disability panel said you're incapacitated. So a new trustee steps in. Now, if it's a co-trustee, so sometimes you may appoint one of your kids to be a trustee with you, or maybe your backup trustee or two of your kids. If there's more than one trustee serving at the same time, it's a good idea to sit down and divide the duties. So who's going to pay the bills when they come in? Is it going to take both trustees to sign every check? So your trust is set up to say either you can pick or choose which child can sign the check, or they can decide between themselves, or the trust could say that they both have to sign each check, which isn't the best way to do it because they may not. That may cause a lot of problems for them. But if you do have co-trustees, then they need to decide who will do what. And it's best if one of them pays the bills and has the checkbook. Now, once you have a backup trustee in there, what are the things your backup trustee shouldn't do? So they divide the responsibilities. The first thing they shouldn't do is self-dealing. So embezzlement. They shouldn't be taking your assets out of your trust. Now sometimes we see kids borrow money from their parents when they're the trustee, and they say, Mom and Dad, I'm sure if they were not incapacitated, they would say that's all right. But that's a no-no. That's embezzlement. And if any of the other kids see that, you can easily be thrown out as trustee. You have no right to your parents' assets if you're a trustee until your parents passed away and the trust says you get them. Just being trustee just means you're in charge.